Let's bring in immigration law expert Ashraf Essop to make sense of this judgment. Ashraf, good afternoon. Thanks for your time with us here on the SABC at this hour.
Good afternoon. Thanks for the invitation.
At this point, let's get your reaction to the outcome at hand.
I think the judgment is very clearly premised on the law as it reads today, and takes its authority from the Constitutional Court case of Ashebo. Now, by way of background, we must understand what has happened. Previously, there was no application necessary for good cause. Now, what does that mean? That post-January 2020, any applicant for asylum had to now produce what we call a application for good cause. He had to show how he entered the country illegally and his stay is illegal or not. So it basically co-joins the expression of an intention to apply for asylum. And the courts found that the mere expression of such an intent doesn't automatically trigger your release. So post the amendments, the Ashebo decision in the Constitutional Court now rules supreme where the following circumstances apply. One, if you are found to have, yes.
Yes, do continue, do continue.
If you are found to have Section 49(1)(a) of the Immigrations Act, which is basically a criminal offense, if I may just take some time to read that, I think it's very important that we get some context, because 49(1)(a) falls under offenses, and it reads, anyone who enters or remains in or departs from the Republic in contravention of this act shall be guilty of an offense and liable on conviction to a fine or imprisonment. So basically, this is where the case came in, where they were speaking. Are you with me?
Yes, we're listening loud and clear.
Sorry, because my computer says I might have lost you. Anyway, back to the topic. So basically, here what the court was saying, no, you can't just come in and then say, once you're arrested, oh, I want to now go and apply for asylum, which is anyone's right if they fit the asylum seekers, let's say, profile. Now, I don't mean a personal profile. I mean that they have to be escaping from some harm internationally, from their country of origin or whatever the case is. And basically, you then have to show that you have a good case against non-refoulement. So basically, the court is saying, we're not sending you back to your death. What we're saying is, you've got to satisfy the Department of Home Affairs officials that you have good cause for illegal entry and stay in the Republic. The court very, very importantly said that they are bound by the Constitutional Court decision in the Ashebo matter. Now, I must say this was a very interesting, very lengthy judgment, and quite quite contested by both sides. But I think at the end of the day, it has now come to the situation where the court is now even directing the Department of Home Affairs in terms of the order that says you must, within 60 days of this order, which was on the 8th of Feb, you must give the applicants an opportunity to apply for good cause and to allow the whole process of any review or appeal, in the event that good cause is not established, to unfold. Now, good cause is not really defined here, and it will depend on the circumstances. But if you take its parallel in the Immigration Act, there's certain directives that have been passed and certain mandatory forms that need to be filled out. In fact, when you first approach the department in terms of section, in terms of the Immigrations Act, then you will receive a Form 23, and once your request for good cause has been determined at head office, they may issue you with a Form 20 that allows you now to go and apply for the kind of visa that you need. But part of that application includes the readiness to demonstrate that you can apply for a visa. Now, in respect of the Refugees Act, although provision is now made for you to show good cause, there isn't any kind of indication what the standard operating procedures would be. But my guess is that they're concentrating on two things: illegal entry and why you didn't present yourself within 5 days to the RRO, which is the Refugee Reception Office, to apply for good cause. So it doesn't take away anything from any other process that is in place. And so they are not at a disadvantage. In fact, the courts were quite clear that the main issues regarding the costs, etc., will be dealt with after the parties are directed to do certain things. So this is not the end of it. The court wanted to hear the parties' representations on costs. But very, very clearly, and I think I think correctly, they've decided that the Bore matter is different from the Ashobe matter. So this is what I'm saying. At the end of the day, the judgment is sound.
All right, Ashraf, thank you very much for that. I actually wanted to look at the timing at all of this, the laws surrounding all of it as well, given the current socio-political climate and the timing of this judgment. What are you observing on that front, just as we wrap up very quickly?
So courts, use the law to find one way or the other. This matter started some time ago, and I don't think it's linked to any socio-economic or other challenges that we may find ourselves, because the Ashebo decision was made some time ago, and so that was the law in place at that time. And it wasn't based on anything else. Of course, the court accepted that the porous borders, the difficulties that people have in trying to evade the processes or distinguish between people who are genuine asylum seekers and the security of the Republic, all that has been pronounced on before. So it's not really important to this case. So very importantly, it is consistent, and it says that we will not be allowing anyone who knowingly breaks the immigration law through illegal entry and stay now to get away, just without showing good cause. So I think there's a gigantic step in that regard.